Suppose the vacation is started from after 2 weeks. Huh? After 2 weeks, we'll lifting. Okay.
Please, Your Lordship. Lordship, I beg to mention item number 1, my lord. I have taken consent from the other side also. Kindly adjourn the matter for 2 weeks.
Mr. Purkasta is there, na? Along with some other.
Yes, ma'am.
Have you taken consent?
Yes,
We are giving you 2 weeks. Forget to handle that.
problem.
Lordship, I beg to mention item number 12, Lordship. Lordship, the matter may be adjourned for the day. Lordship, I am appearing on behalf of Amicus D. Saikia, Lord.
Amicus D. Saikia. It is an order column. What was the matter? Case was in the order columm.
Lordship, I don't.
Case was in the order column. You don't know about the case, I think, na? কি কৰিব মানুহ অহা নাই মই সুধিছো আহা বুলি already there are two orders, number 1 and number 2 weeks to be diagnosed. At the concept of the other set, the petitioner has to and item number 12, you are Mr.
A. Iqbal, Lordship.
Item number 12, Mr. A. Iqbal, appearing on behalf of Mr. Why you need an interpret?
Lordship, she is not well, actually, Lord.
Mr. Saikia is not well. Oh, MSD Saikia.
D. Saikia.
MSD Saikia. It will be listed after 3 weeks.
In respect of item number 4, my lord, the counsel for the petitioner is out of station. It's coming today. Can it be taken up next week?
Item number 4.
4, my lord.
You are for?
I am for the respondent, my lord.
You are the respondent.
Counsel for the petitioner is in Kolkata, is on his way back, my lord.
Start. Next week you want?
Lord.
Up to 1. Give it time.
Lord.
May I please, Your Lordship, please, against the impugn order dated 29/5/2020,
Against conviction.
conviction, Lordship,
Against conviction.
against conviction. 6 months for offense under section 448 and 7 years for 376, Your Lordship.
Okay, can be admitted.
Yes, my lord.
In the first order, LCR is not called for.
The LCR is not called from.
Today is first date for admission.
Admission.
LCR may be called for, Lordship.
You are Mr.
A.R. Shom.
Mr. A.R. Shom, done it for the petition. Apparent. K. Bush, na? Yeah.
K. Bush.
Done it. Then appeal filed against the judgment and order. Admit for hearing. Call for the. Is there any other
Private respondent is there.
private respondent?
Not
No. Issue notice on the private respondent number 2 register. No. Yeah. To jurisdictional included the office of the public prosecutor raised, also called for okay, we are calling for a call.
Oblige, Your Lordship.
Then appears on court. The service is still awaited for this one.
145 proceedings.
Oh, 145. The service is still awaited, I think. It- No, it didn't. Appears on court. Petition. Hard discharge. And at that, the this is reporting. It's a case of 2013, na?
Yeah.
So one.
In this case, I am praying for withdrawal, ma'am.
Withdrawal.
Yes, ma'am.
For the criminal petition in connection with criminal activity, na?
Yes, madam.
You want to withdraw?
Yes.
Your name, good name?
K. Kolita.
Participate. Apparent that participate. Where
Homeless.
Miss Williams, we need 3 weeks time to take a first step upon the respondent on 2, my lord.
respondent number
2, my lord.
your Mr.
V. Baskor, Vinod Baskor, on behalf of B. Chaitanya.
Vinod Paswan.
Vinod Baskor, VASF1.
Mr. Passport appearing on behalf of Mr. And also for the office notes 10-9 that steps are not yet taken against the number. However, Mr. Passport submitted within the apparent takes the prayer take the matter record. Okay, to take steps.
Deeply present.
My lord, this is a file
Oh,
against
it
the
is
acquittal,
state.
my lord. Yes, my lord.
Ah.
My lord, here we need 2 weeks time, my lord, because in earlier occasion, my lord was pleased to direct us to take steps to the OC concern.
Hmm.
My lord, that report we have not received. Maybe allow us 2 weeks time, my lord. Earlier we have to take the steps to Talavana. That was made. After that, my lord, by the order dated 12/9/2023, my lord.
Hmm. You are
Honorable-
directed to take steps to judicial police station.
Yes, my lord. Yes, my lord.
For the app. It's submitted that in advert it could not be taken. To do it. To respond it to as that is called had ordered it 12/9. Prayer up that after the take rest two is the matter. Okay, it takes it after 4 weeks. It will be
Yes, my lord. Concerned police, through concerned
through
police.
consent.
Deeply obliged, lord. Thank you.
May I plead your lordship? Plus, as per office note dated 14/8/2024, Written objection is have been filed by on behalf of state Your Honor.
14.8.
14/8/2024. Your Lordship.
You have filed your written objection.
Yes,
Written objection.
that is withheld.
It's an IA.
Yes,
Aye.
I with him.
So then you want to argue the matter today.
No, not today, Your Honor. Give us a short date. It's
Have you received the copy?
Yes, I've already. Yeah, after puja.
You are
Your-
Mr.
N. Mili. Lordship.
Card Mr. and Mili done for the that's the not the card done on for office note dated 14/8 that it state has state responded has already back. However, Mr. Mili subject some more time to be required for this the matter actually after vacation you
After
want
puja.
after immediately after.
Much of it.
May I please your lordship?
Yes.
In this case, lordship, we have already taken steps upon respondent number 2 by register post with AD as well as through usual post. But from the office note dated 10/9/24, it appears services awaits.
Whether there was any order to district magistrate order was there?
Yes,
No, to issue notice to district magistrate. Is there any order earlier?
yes.
Yes. Then- So as per office note, your service is not yet completed, na?
Yes.
From office note, it seems that you have taken steps on 10/9. So let
Yes,
the service
Lordship.
be awaited till next date of district.
Yes.
Hard MS, you are Mr. MS.
You Sharma.
Hard MS Sharma, Kedanet counsel for the petitioner. From the office note dated 10/9/2020, that services not yet, the services still awaited for the sir. No, the services await go to the next. This is the matter. So we are awaiting the service till 3 weeks. It will be listed after 3 weeks.
There is an I also.
Yes.
Let the interim order may allow to remain in previous bail till today. So, Lordship, I pray that interim order may be allowed. Oh, pardon.
Was there any interim order?
Yes.
Interim to give I interim order dated 24/8/2024 taken till next.
Oh, bless you.
Yes. What is the office note here? Objection you have filed up. Objection has not been received. In the state object, no objection is there till now.
But delay continuation is there, Lord. I think, Lord.
It's a delay continuation.
I think, Lord. Delay, no? Or delay.
No, it's a leave petition.
Respondent number 2 to 5, they are supposed to file objections, Lord. 2 to 5.
Oh, acha.
Leave
Leave the answer. Leave the answer. One leave application, leave petition is there.
Oh, Lord, leave petition.
Then why I is there? I is for what?
I have to leave petition. You can leave petition. Petitioner stated here. He is respondent from. He is from respondent side. Lord. He
Oh,
is
you are for the
standing on
respondent.
that side. Lord.
Oh, acha.
ক'ব লাগিব। তুমি এইটো ন respondent তুমি respondent নে petitioner? আমি respondent। এইটো চাই। petitioner অহা নাই তেতিয়াহ'লে ন? ইয়াত নাই।
So want to ask you one thing.
Sure.
One leave petition was there.
Lord, please.
Against an equity order was there. Anyway, one
Right.
leave petition was there. There, the respondent number, you are representing in 2 to 5, I think.
2 to 5. 2 to 5.
2
2
to
to 5.
5.
No? 2
And
to 5.
2 to 5,
Lord, please.
take time to file their objection.
Objection.
It
Lord.
was also allowed.
Right.
And then as per office note also,
Petitioner নাই নহয়।
one no objection. He was no objection court. Then what has happened? This interlocutory application is filed only for, I don't know, only one prayer is there that objection, their objection is there in granting leave.
I is for what, Lord?
That is too questionable. I is for what? Depend-
I is helping in amateur.
This is for saying that the leave petition should be dismissed.
Dismissed, Lord.
But it is prayer from the respondent side.
Yes, yes.
The leave petition
Lord.
filed by the appellant or petitioner
Lord,
side, that should be dismissed. For that only they have filed this one. That is also surprising. I don't know why. They could have raised objection there only. There in
Lord,
the
please.
petition itself.
Lord, please.
How can I help you?
Yes, Lord, if they are objecting
Hey,
for.
their objection, if there is objection,
No, they were
I
arguing.
want to say one
Lord,
thing. Now, the question is that if you have any objection, Mr. Counsel, if you have any objection, suppose, in allowing or granting the leave of this court, then obviously it is the scope. You can object. You can file your objection, you can file your affidavit in opposition, whatever in one manner. But why I? I just not follow you. Why I is there? One separate requirement of one separate I is not there, I think.
Yes, they are filing I, Lord, report there. I don't know to confirm.
Just I want to say, you are Mr.
AK Kanu, on
behalf of M.
Ahmed.
M. Ahmed, na? Your senior. So I don't want to pass any order today because I cannot be entertained in fact. It is not entertainable. I don't want to dismiss today. The matters may be listed after 1 week, but the matters will be there. How is that? And you also consult that there is no necessity or no requirement of filing this one. If you have any objection, till now I'm just saying, if you have any objection, file your objection. Because otherwise there may be the prayer may be allowed. So by the time you file your objection, we'll see to it, we'll consider it. It's
May it please your lordship.
Yes.
My lord, this I is for suspension of sentence, your lordship. The appellant was convicted under section 304B for 10 years and 498A for 2 years. And since judgment, he is in jail custody. We have filed objection, your lordship. We have received the copy.
You have filed the objection.
Objection.
You have made a party on Mr. Mubarak Hussain. Who is he?
Mubarak Hussain, informant. Informant.
Have you taken any steps?
The steps we have taken, but lordship, as per office note dated 28/8, lordship, as per 28/8, your lordship, the service reports away. But lordship, possibly, lordship, they filed objection, lordship.
Yes, Mr. So it is a case of conviction under which section?
304B for 10 years and 498A for 2 years.
So 302 was not there.
302 was
Initially, 302 was also there.
Initially 302 was there. If your lordship goes to the evidence, your lordship, the ingredients of 304B is totally missing in the entire case. The affair was lost, your lordship. There was a delay of 1 month. There was the delay. The incident took place on 7/10/21. The affair was lost on 7/11/21. And prior to the lodging of that FIR, your lordship knows that there is no allegations, no FIR regarding dowry, demand of dowry by the husband or relative of the husband, your lordship. Then your lordship, they have alleged in the FIR regarding that there was a dowry demand and torture, but PW7, the investigating officer, in his cross, why he has clearly stated that while recording his statement under section 161, the informant did not state before him that his mother told him that the accused person demanded dowry from the deceased family. And at that relevant time, the deceased husband was watching IPL match with his friends, and which the DW2 and DW3 has confirmed that. And lordship knows that at a relevant point of time, the demand of dowry should lead to the suicide of the victim. But that could not be proved, your lordship. That could not be proved. And during the trial, your lordship, the appellant was all along on bail. He never misused any condition on bail, and now he is in jail for almost 6 months. And earlier also, during investigation, he was almost jailed for 3 months. So considering all this, he has a child also. The mother is in the other world now. So his child is there. Approximately 6 years. So considering these aspects, my lordship, his sentence may be suspended. Lordship, because already 6 months in jail, he is in jail, and they have got a child also. And 11, no? If not the permit, I would like to take one judgment of the DDS. Paragraph 11, your lordship. Paragraph 11, may I read your lordship? Lordship has got paragraph 11. Lordship knows that, but even though I refresh your lordship's memory, to attract the provision of section 304B, one of the main ingredients of the offense which is required to establish is that soon before the death, he was subjected to cruelty or harassment for or in connection with demand of dowry. The expression soon before her death used in section 304B and section 113B of the Evidence Act is present with the idea of proximity test. In fact, the learned counsel appearing for the appellant submitted that there is no proximity for the alleged demand of the dowry and harassment. With regard to the state claim, we shall advert to the same while considering the evidence led to the prosecution. Though the language used is soon before her death, no definite period has been enacted, and the expression soon before her death has not been defined in both the enactment. Accordingly, the determination of the period which can come within the term soon before her death is to be determined by the courts, depending upon the facts and circumstances of each case. So here before there was no demand of dowry, there was no allegation, no FIR, nothing. But unfortunately, the victim died, your lordship, but she hanged herself in a bamboo where clothes are being hanged. Then she got hurt because the wall was the thatched wall, bamboo wall that was nearby. So she got hurt. The PM report will prove that it was. On the same line, there is another judgment lordship may take into consideration also.
Well, looking into the evidence of PW2, who is the mother of the deceased lordship, she has clearly stated that one day before the incident, she was assaulted in her legs and she was limping on that day. Moreover, lordship, she also stated that on the previous occasion, she also been assaulted by her husband, but she stopped her mother to inform to anyone because otherwise she will be again assaulted by her husband. So it is explained. Moreover, the delay of 27 days is there, but it is explained that because the PM report is not there, so they has not lodged the FIR. Moreover, if we look into the postmortem report, lordship, there are injuries on nose, face, fingers, and in the cross of the doctor, he has clearly stated that these injuries are not because he has committed suicide. It is not during that period. And moreover, lordship, it is in 304B, it is clearly stated that she was subjected to cruelty soon before her death in connection, as it is soon before, one day before, prior to the incident, lordship. Moreover, section 113B also comes into play, lordship. Presumption is there. And moreover, she was married for 4 years before the marriage. It is well within the 7 years of which is there, one of the ingredients, lordship. So it comes under the ingredient. So I objected.
The postmortem was available on the very next day. She died on the very next day. Postmortem was held and the report was available.
The injuries are also there.
Injuries, I have explained your
on
lordship.
face also.
Face, she hanged herself in the alna, lordship of bamboo alna, she got hurt. And while the lordship may consider the difference with DW, they have clearly stated that the husband was watching IPL and they only removed her.
She might be hanged, but drive her to commit suicide. There are the instances.
possibly, my lord, with all respect, my lord, it may be a case of 498, but not 304B, because there is no such incident which compelled her to commit 304B. Considering the detention period, and he was on bail earlier, never misused any condition of bail. They have got a child also 6 years, and there is possibility of acquittal also.
After the presumption of innocence has gone, as because he has convicted Lordship.
PM report पण असते ना.
Moreover, 164 statement is also there, corroborate with her evidence in the PW2, SPW2.
How many DWs except 3?
On the page 28, Lordship will get there. Only 3 inches gap there was between the wall and where he was hanged. Page 28. An injury may be possibly due to some scratches with the.
The cross of doctor is there, Lordship, on that point. Okay.
The next 9 there is it is that the two at the case of section 498 but such and come and come is freedom for it and husband of the president along some dead and the brought record by a of the street supported it and stated that he was enjoying progress of and he was enjoying the IPL match. But there are there are some contradicting evidence in video and there is a chance of succeeding in an appeal filed against it filed by the present he enough as on it. It will be a he further died of the Honorable Epic Court reported in 12, 11 and 16, 397. Mustafa Shahadal J from the state of Maharashtra and the size of interactive from the assessment where it has been observed by the Apex Court that main ingredients of this quite is that soon before her death, she was subsequently for or if connected to the para irrelevant portal. That not be that another code report 161 certificate and another certificate when it observed that good cannot be the truth or be immediately good reported that one immediately good of contributed much of the evidence of wrong and typing between the term and related to our harassment for dowry demand by the court and of the that and cannot okay but that unacceptable okay that's a bit of that a dot permanent comma that a dot of subject and that dot and one day before the dot dot but a daughter and with after not to and web and it that with and uh, not right but it of for her harder that the photo did particular postmortem before the day of that it that so for for her that to take because such that for that it that happened for at the time uh, that's what the but but that of him not that it both and therefore that the profitability that the that and that part record evidence record the that whatever the part bit from so as per evidence of the as per the report of evidence of doctor see that
It only 6, your lordship.
there were yeah, 7 of the top mark of admission and mark of honor they note in her magazine area of trade, including markers, including on entries on markers and index for right and it is that from cross it is sort that doctor that packet of that 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 the budget that is got me but uh, but that like it that the kind of thing on a base of white the by a person who make her the back her it is allowed sets of both your petition stands.
Oblige, your lordship. Oblige.
Appeal to appeal. Appeal, you have not taken steps for the respond number 2.
No, we have taken steps, your lordship.
Not yet
Awaiting.
awaiting. Still awaiting.
Awaiting.
And LCR has already
Oblige.
placed. After.
May I please go?
Yes.
My lord, we have taken steps here.
Hmm.
Well, what happened in this case, my lord, is a purely, my lord, civil nature, my lord. And we have made a, my lord, power of attorney at Udalguri, my
No,
lord.
no, civil nature is not a question. We have made, AD card and notice is not yet received back, returned back.
I have checked, my lord,
No, as per the office note dated 3/9/2024,
my lord.
the notice issued on the respond number 1 and 2 by the registered post is not yet returned. So, do you want to await for this process or what? Await it till next 2 weeks then?
My lord, my date may fix, my lord.
Date, we are not in a position to fix any date. In fact, can we? After vacation, then it will come. Immediately after vacation.
My lord, I think whatever, my lord, I want a stay, my lord, because yesterday, my lord, there was a date fixed, my lord. We appeared, we took bail, my lord.
You took bail.
My lord, there,
Then you are on bail now.
my lord. Because, my lord, case, my
No,
lord,
in case an order comes, they are not going to hear the matter.
my lord,
At a date you were now next date when your next date is fixed. Can you tell?
my lord, after, there also after puja vacation, my lord.
No, here there to one definite date has to be fixed.
Yes, yes. There's a
Yes.
date, my lord, but my
You
participant
have,
informed me.
don't have. Okay. এটা আমাক জনাব পাৰে, otherwise will be after vacation. After vacation. You made a prayer.
My lord.
I wait for that.
May I explode? My lord, as per the office note, my lord, service report upon the respondent number 2 is awaited. my lord.
Still awaited.
Yes.
Oh, you have taken steps. Acha, okay, then you have. This is the note of 11.9, na?
My lord.
You took steps on 3.9, so it can be awaited, I think.
Yes.
Because the last order was of month of April, in fact.
April.
So after there, you have taken steps.
Right.
So let this service be awaited to respond number 2.
Right.
State is respond number 1.
What?
As per office note dated 11/9/2024, still awaiting for number 4 or 2, and it reveals that step taken on 3/9/2024. According to await for the it's accordingly after 3 weeks. This after 3 because 2 weeks
Mal.
puja vacation.
Let it be 3 weeks. Oblige. Wait, please, Lordship. Lord, as per order dated 26/2024, my lord, passing the main case, I have made the victim as a party, my lord. I have annexed the order, my lord. Is it page 10, my lord? In my IA. This honorable court has directed me to implement the victim as a party, my lord.
Okay.
That notice may go at this stage, my lord, to the victim, my lord.
So it was order was passed on 2006.
My lord.
So for I, why you have filed I to
For implement, my lord.
Fine.
For implement as victim as the party respondent. As a respondent number 2.
It's a case of POCSO or
My lord, what happened, my lord? It is 376, my lord. Between them, my lord, amicably settled, my lord.
it's already
Therefore, my lord, we both, my lord, the informant as the, my lord, the accused jointly filed an application for quashing of this, my lord, FIR, my lord.
so this is for washing only.
Quashing, my lord.
If it is that washing, then she is party. It is jointly filed.
Jointly filed state was made a sole respondent, my lord. Because the victim was not the informant, my lord. Victim's brother was the informant, my lord.
Then this is, how can you say this was a joint application?
My lord, this is Hyder Ali. Hyder Ali was the informant, my lord. Then 2 and 3 are the accused persons, my lord.
But
Case was
is not separate.
amicably settled between them, my lord. As the it is, my lord, not compoundable
Now
offense, my lord.
this victim will be made as a party
In the as respondent number
respondent.
2, my lord. As the offense is not compoundable, my lord, that is why, my lord, respondent is.
not at all. That is
376D, my lord.
He is there.
My lord.
376D, how working is there. Heard Mr.
TK हुई है, my lord.
Your name is not
Not yet, my lord.
PK Bhuya.
My lord.
Heard Mr. PK.
T for team, my lord.
Huh?
T for Tamil.
PK Bhuya did not constitute evidence. Petitioner plus applicant. Also heard this I certificatory specified only for the implement of the victim as a response number as per order dated 2006/2024 by this court in criminal petition number 16/2024. It is submitted by Mr. Yam that the only victim are already compromised the matter. However, in the joint application, the response the victim was not made as a party and said application is filed jointly along with the informed. And hence it was required implicit victim as a response number 2 in person to order it when is no according to the present directing the present that by to 15 the responsible and by another cost that according
My lord.
in the tribunal number 30 and will also take for the newly the observation objective to participant in view of order passed in High Tribunal 776 of 2024, the 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 petitioner is hereby directed to file an amended contract to amended contract and also take the record.
Interim order dated 26 only 2024 may be
Where is
continued.
the order? Interim order dated
20/06/24.
2006.
My lord. In the main case, my lord.
What's it? Here.
My lord, till the next date of posting, the petitioner number 20 shall not be arrested by police.
Interim order be accepted till next.
I'm deeply obliged, my lord.
Yes, what is the I about?
Please, your lordship. My lord, what happened? It is we have challenged the 125 proceedings for maintenance of 4,000 was granted against me. My lord, the claim of the respondent is that she married me by virtue of an affidavit, and we have come to know when affidavit was sworn that one Ayubali is the husband of that very lady. Then we have this affidavit was cancelled. Then, my lord, she filed a domestic violence case against me, where her contention was rejected by the court below. Then she filed a case under 498A against me, to claiming that I am the husband, I am harassing her. That was also rejected. Then, my lord, as a last resort, she filed 125. In 125, Learned Family Court Nalbari has granted 4,000 rupees per month, and that we have challenged. Your lordship, while in a motion stage, admission stage, has stayed the interim order of the Learned Court below, and they have filed the affidavit. We have given a reply here. But what happened on 5/6/24, when matter came up in the court number 20, because of my illness, my lord, I asked my junior to pray for an adjourn. But Learned Court said that it will be taken up when your term will come. But when later on it was asked for, but my junior was absent. That's why, my lord, interim order was vacated. Now we have filed this case.
File before the court number 20 appropriate. That is not proper, in fact, because one observation was made by
Right.
the court.
No. Court has begun passed very rigid order,
Yes.
said that you pay the maintenance, but however, it is made clear that observation made in this order is for consideration of the issue to extension of the interim order, and the same shall not influence the determination of made by the touching merit of the case. The Honorable Court has expressed that idea also.
When you want any date or
Any date, my lord, as per your conference, it may be fixed up, placed before the appropriate court.
appropriate court after 1 week, then
Yes.
before vacation it will be done.
Yes.
Okay, after. You were on 18th. I for what? Oh,
I for correction, my lord.
in মানে আগতে কি it was not under PNS.
My lord, in item number 1, there was an interim, my lord. That may be continue.
Item number
1. I made mention.
Updated email. Item number 1.
Yes.
It was there.
Deeply up.
Otherwise, to say, when in fact,
Yes, ma'am.
the additional PP had some problem. You were there.
My lord.
Up to 3, it was continued. In fact,
Yes,
the
yes.
code number, yes.
Yes,
That's
my
why
lord.
I got time to post it.
Yes, my lord. Yes, ma'am.
Otherwise,
That was taking time, both the matters, 7 and 8.
yes.
Yes.